After slavery was abolished in the United States, the 13th, 14th, and 15th Amendments were passed to give African Americans legal status. Even though these amendments were passed to help make America more equal, there was still segregation in America's schools. In the ruling of Plessy v. Ferguson, Congressmen ruled that separate but equal education was constitutional. In 1909, the National Association for the Advancement of Colored People, also known as the NAACP, was created, and they worked to end discrimination and segregation in America, but focused on the desegregation of public schools. There were many protests involved that were led by students who realized that segregated schools were not equal in the quality of education and funding being given. These were small steps in the right direction, leading to the desegregation of schools in America. This is where the Equal Protection Clause comes into play. The Equal Protection Clause of the United States prohibits states from denying any person within its territory the equal protection of the laws. This means that a state must treat an individual in the same manner as others in similar conditions and circumstances. The Equal Protection Clause and the following cases are how America was able to get away from segregation in schools and led students of all races to have equal educational opportunities.
One of the first cases violating the Equal Protection Clause was Mendez v. Westminster in 1947. The case took place in the County of Orange in Southern California, where school districts were segregating Mexican-American students from white-colored students. About 5 years later, the case of Brown v. Board of Education came into existence, but this time involving the segregation of African-American students. For both cases, the U.S. Court ruled that segregation in schools violated the 14th Amendment's Equal Protection Clause because schools were not equal in resources and quality. But why was segregation not the issue? This leads us to the affirmative action cases, Gritter v. Bollinger and Gratz v. Bollinger. The conflict of the cases were minority students getting admitted over white students in the University of Michigan. Does a school violate Equal Protection Clause by rejecting majority students to increase diversity? In the Gritter case, the court's answer was no, and in the Gratz case, the answer was yes. Another recent Equal Protection Clause case is Enju v. Douglas County School District. This case is about students with disabilities receiving free, appropriate public school education and progressing to another level. The U.S. Court decided to enact the Individuals with Disabilities Act, requiring schools to offer an individualized education plan to help students progress according to their circumstances. Each case states the right for every student to attend a free public elementary, junior high, and high school.
The judicial branch is a system consisting of federal courts and judges that interpret and apply laws that are made by the legislative branch. The primary responsibilities of the judicial branch are interpreting laws and applying them to everyday situations. The main reason why the judicial branch exists is to decide what actions are protected by the Constitution and taken in everyday situations like the 7 court cases mentioned above. With the mentioned cases, the judicial branch made sure to implement the laws that were enacted, such as Title 6 and 9 of the Civil Rights Act, which prohibits the exclusion of a student based on race, color, sex, and the Rehabilitation Act, an Individual with Disabilities Act, which prohibits the exclusion of a student from educational opportunities based on disability. The judicial branch has always applied laws to everyday situations and looked for the best. With education cases, there are many disputes that contain race, sex, religion, disability, and much more that have been argued throughout the years. The topics that include race, ethnicity, and disabilities in school are taken very serious and remain a big problem to this day. But with the help of the judicial branch, we can continue to promote change by understanding that being different on the outside has nothing to do on how far we can go to achieve our goals.